Welcome to The Property Planet, a podcast with Simon Howley and Amanda Perrotton of Howley Perrotton, the show all about the tax and legal issues surrounding property ownership, where we discuss everything that affects property investors and developers and go deep into the detail to unravel the advice, highlight the traps you can fall into and dispel the myths surrounding property ownership in the UK.
Hello to all our listeners and welcome to the Property Planet podcast. Once again, delighted to be bringing an absolute expert in his field, Patrick Cannon, to our listeners today. We're very grateful to him for his time, for joining us, and we look forward to hearing all about the updates for the cases that are coming through at the moment. So good morning to you, Patrick.
Good morning, Amanda, and good morning to, or good afternoon indeed, to anyone listening to this. It's a pleasure to be here, and it's great to see you again.
Yes, and you. So, there's a lot. I feel that there's a lot going on at the moment, particularly with the fact that MDR went 1st of June, obviously last year, but there's a lot of interest for uninhabitable dwellings, the continuing appeals that are coming through for people claiming MDR. There's a particularly notable case that I'm sure that you'll cover that you represented the appellant on for Charlie Johnson, and that is, very interesting, given a couple of points on there that that seem nuanced, as always these things are, particularly to him, but be interesting to see. Start wherever you would like to, but yes, what you feel the updates are, particularly in the light of the changes that are going to come again from the 1st of April.
Well, we can probably start with Charlie Johnson. That's the most recent decision that of an appeal I've been involved in, and that's an interesting case. Although, as you've noted, the MDR has gone since the 1st of June last year. There are still a few cases coming through. And in Charlie Johnson, was a typical case involving an annex that was attached to the main dwelling. But I'd like to say in that case, we had a fantastic judge, and I hope I can pronounce this correctly, Judge Natsai Manyarara, if I've got that correctly, and Mohammed Farouk sitting with her. And of all the appeals I've done, she's far and away the most professional judge I've experienced in the FTT. And I'm not saying that because we won, but that the whole appeal was just handled so professionally and fairly. And she listened carefully to Mr. Johnson when he gave evidence and assessed his evidence very thoroughly. Now, and Amanda, do please jump in if you have any questions at any point or wish to make any points. But Charlie Johnson, MDR case, and unusual in that the internal connecting doors in that case, which are considered to be absolutely mandatory based on the existing case law, the doors were not lockable. And
that for me was just something I thought, gosh, that's quite an interesting point. I mean, as you say, there's certain things that the criteria, usually people are, does it have a bedroom and a sitting room? And you tick off all of the points that you feel should be an absolute. And with this one, and also, door braces fitted after completion, just really interesting points. So I'm fascinated to hear about how you won.
Well, in no small part, in fact, a large part of the victory in that case was down to the thorough preparation by a person instructing me called John Fitch of SDLT Experts, who did an amazing job in terms of assembling evidence of comparisons where HMRC, for example, said this can't be a separate dwelling because you can just look in the windows of the annex. So there's a total lack of privacy. Well, John produced dozens, possibly hundreds of pages with colour pictures of, for example, terraced homes all over the country, where you can simply walk past on the pavement and look in the window. but HMRC don't regard those as not being dwellings in their own right.
Well, and also differs. I was looking at another case, Fitzgerald, and one of the reasons that failed, it fell down on the point of the configuration, and I just thought, particularly if you were sat in the garden, you could look into the dwelling, and I thought, well, gosh, that is very closely aligned to the comments that were made in this case.
Yes. So John Fitch provided me with all sorts of very helpful evidence to put before the FTT. And then Charlie Johnson, the purchaser, gave his evidence. And the case, as far as I could see, pivoted on the door brace point. And I'd not come across these before, but they're amazing devices. And we produced pictures of them, and Charlie Johnson explained how they work. And I've recently, since that case, I've seen examples of door braces which are actually only about sort of 8 or 9 inches high, but they still do the job. And you fit them to both sides of the door, and they prevent the door from being opened unless the person on either side of the door releases the door brace. And the beauty of those, of course, is that they do provide the necessary privacy and security, and they can be fitted without causing any structural complications, as the judge pointed out. HMRC's own guidance says that the doors must be lockable either at the effective date or adjustments can be made without causing any significant building alterations. And this perfectly fitted the bill. And indeed, Charlie's evidence was that they were not fitted at the effective date. They were fitted a couple of weeks after. I was a bit concerned about that.
Well, yes, yeah, I can imagine, because that was something else I should have, just making notes. And thought, oh gosh, actually at the effective date, which of course is always the important point that you're hanging your hat on, what the effective date is and what the situation looks like at that point. And I noted that they weren't there then.
Well, on that point, I think the judge got it absolutely correct, because she said, well, the annex was nevertheless suitable for use as an annex because you could fit these door braces without any major building work.
Mm-hmm.
And so she relied on the suitability of use point, which, if you think back to Fiander and Brower, Judge Citron was very strict in saying you take a snapshot at the effective date.
Yeah.
And in terms of suitability for use, essentially you can't take into account any alterations. And in Fiander and Brower, of course, we had an old brick bungalow that had been attached to the main dwelling by a subsequent hallway being built, and the internal connecting door had been removed. And that was enough to fail the MDR claim, even though you could have dropped the door into the door jambs.
Yeah.
No building alteration.
Yeah. In a similar way that you could put these braces on, I guess. Yeah.
Exactly. So Judge Citron probably would have said door braces no good. But I pay tribute to this judge. I think she really took a really independent, correct line.
Yeah. And as well, I think the effective date point, that has been really restrictively and strictly interpreted for many cases. And of course, at the effective date, I suppose it was still suitable to be treated.
Well, we get on then to the contrast between the uninhabitable dwellings cases and MDR. MDR, the line of cases up to Charlie Johnson, was that suitability for use was interpreted very restrictively. And Judge Citron and Fiander being a great example. But the same statutory wording in Section 1161 of the 2003 Act for uninhabitable dwellings, suitability is interpreted extremely widely. And the Mudan case in the FTT is a great example of that, where, according to Judge sorry, his name has escaped my, no disrespect to him. The building basically had to be radioactive or falling down before it wouldn't be suitable for use as a dwelling. And in that case, he said, yes, it was Mark Baldwin, at paragraph 53 of his decision in the FTT. It might be worth me just reading that out because I think it sets the context. I consider that a building which was recently used as a dwelling has not in the interim been adapted for another use and is capable of being so used again. A building such as the one in Bewley, the defects in which cannot be put right at all, will not be capable of being so used, will count as a dwelling even though it is not ready for immediate occupation, unless the reasons why it is not ready for immediate occupation are so fundamental, being radioactive or at high risk of collapsing, for example, that the work required to put the problem right goes beyond anything that might ordinarily be described as repair, renovation, or fixing things. Examples of this sort of work, that is fixing things, being installing a new boiler or heating system, damp problems, or floors needing replacing. So that's a very wide approach to suitability for use, which essentially knocks out nearly every dwelling from being within the uninhabitable.
I mean, we've got them at the moment where it's not, to all intents and purposes, suitable as a dwelling because it's not structurally unsafe, but it's unsafe from a health perspective. But, even though the clients can't move in and wouldn't be able to move in until this has been dealt with, and there's quite a process with removing asbestos and the time period being left between once it's been uncovered and then it's been removed and then the building's allowed to sort of effectively settle again. I think it would be quite reasonable to interpret that as uninhabitable, but you do have some reservations saying to somebody, because ultimately it will be suitable as a dwelling. And so within the definitions and the judgment that you've just, or the paragraph that you've just read out, you're not very confident of how it's going to proceed.
Well, exactly. And I was very surprised at the decision in Mudan, because we had, among the evidence, we had a report from an electrical contractor that had been done before occupation by the buyer and his family, that the dwelling was too dangerous to live in, that the electrics could be fatal and needed complete replacement. The basement was flooded. There were problems with the roof, letting rain in, and the boiler didn't work, etc. But on the electrical report, which basically said don't live there, too dangerous, that was interesting because although HMRC had that report for over a year before the case came to a hearing and had been commenting on it, and it was in the bundle and so on, HMRC instructed a barrister, I think late in the day. Well, I think he was an internal barrister at that point, although I think he's left HMRC now, who on the morning of the hearing objected to the electrical report and said, this is an expert report and there's no directions for an expert witness, which was a total ambush. Now, if the taxpayer tries that sort of stunt, judges normally come down on them quite hard, but Judge Baldwin took it in a fairly, shall we say, restrained manner and said, well, I'll allow it, but I'll give the weight that I think is necessary to the report. But then, of course, he dismissed the whole thing by saying, well, you just, in effect, you just rewire the property, so it's still suitable for use. It's fixing things.
Yeah.
And on the flooded basement, he said, well, I've lived in places that have had flooded basements. It hasn't stopped me. So with sincere respect to Judge Baldwin, I mean, I think some people would be surprised at those approaches, but that shows you how high the bar has been set.
Yeah. You did have a successful appeal last year, though, Dave. Is it Gilbert? Am I pronouncing that correctly?
Yes, I only regret this was just after I think there was a practice direction or guidance issued by the president of the FTT saying that really the sort of default procedure now would be for a summary decision unless the parties want a full reasoned decision.
Mm-hmm.
And whether that's for cost reasons, I'm not sure. I don't know how the judges get paid, but I imagine if they have to write a detailed decision, it'll take them several days, and perhaps they're on some kind of per diem or something.
Mm-hmm.
Hence the pressure to produce summary decisions. But that was an interesting case. Before I get into the details of why it was regarded as uninhabitable, just to explain why it's a summary decision and doesn't go into the detail. Essentially, the reason is Judge Rankin gave his decision straight away at the end of the hearing, which is pretty unusual. They usually like to go away and spend a few weeks ruminating. And so at the end of the hearing, he asked us to stick around for 10, 15 minutes while he discussed the matter with his fellow judge, and they'd come back and give us a decision straight away. So because of what I'll explain in a minute, we were quite surprised when he came back and said, we agree with the appellant and this is an uninhabitable dwelling. And for that reason, he then said he proposed to issue a summary decision. Did anyone require a more detailed decision? Of course, HMRC, because they had lost, that probably was why they didn't want a detailed decision. And I think on our side, we were so delighted.
Euphoric.
Exactly. And to be told straight away you've won, that certainly going through my mind was the possibility that if we asked for a detailed written decision,
he might change his mind.
You've got it. Grab the victory.
Yes.
While you can, take the victory. Don't risk anything to undermine it. So that's essentially why the decision itself is only a few lines and doesn't give away the reasons. But the reasons for the decision in that case were because of structural issues. The front supporting wall of the dwelling below the front bay windows was crumbling and in need of replacement. The whole front of the building would have fallen off. And the joists on the top floor supporting the ceiling were also rotten and were being supported by acro posts. So the whole ceiling was in danger of coming down. So that was decided essentially on structural issues. There's a very interesting aspect to that case. If you'd have asked me before that case about the merits of an uninhabitable dwellings claim, and you told me there were people living there at the effective date, I would have basically said, no way, don't try that. I mean, the clue is in the term uninhabitable, and if there are people living there,
yeah,
you're not going to win. But during the hearing, we were going through the witness's evidence and the colour photographs of the building at the effective date, or leading up to the effective date. And the judge was shown some pictures of the kitchen, and he was eagle-eyed, and he said, hang on a minute, what's that in there in the corner on the counter of the kitchen? We looked, and it was plates of food.
Right.
And there were cooking implements and crockery. And then when we looked at the picture of the bathroom, there were toothbrushes and toothpaste. And he said, is there somebody living there?
Yeah.
And the witness said, yes, actually there was. And I thought, oh no, this is going to kill it. But the explanation was that the seller of the building had inherited it. He was a taxi driver. He wasn't very wealthy, and his elderly mother needed care. And he, rather than move her into a care home and pay the extortionate fees, there were parts of the house that were suitable for her to live in. So he moved her in with a carer rather than pay the fees for a care home. And that's who was living there. It was a kind of temporary arrangement pending the sale of the building. So on that basis, the judge thought didn't really affect the uninhabitable nature, given the serious structural issues.
Right. Okay.
So it just shows you, you can. It's reasonable to bring these cases to the tribunal, despite the fact that sometimes the evidence suggests, you're probably going to.
I think that is quite an interesting point, actually, because I think, as with any relief, I mean, there is an element that there needs to be parameters in which the relief can be claimed. But also, when you try to explain to people, well, it could be this or it could be this, it sounds as if you're being very woolly. But I think just in these few cases already that we've highlighted, the similarities and yet the differences where you would think automatically they would fail, both for the door braces and for the fact that you've got your elderly mother and carer living in the property, you would think that they would kill that stone dead, and clearly neither have. So I think it's fascinating that it's important that everything turns on its own facts.
Absolutely. And I find the quality, it's very important to call witnesses. Judges like to see and hear people with first-hand knowledge of the building. It'll usually be the purchaser, although in the Trechikov case we can talk about, it was the seller. And these cases, a phrase I don't really like very much, but HMRC use it a lot, a multifactorial assessment.
Yes.
Is what's important. And it's a value judgment at the end of the day for the FTT. And honestly, as long as you've got reasonable grounds, it's worth going to the tribunal, because, it's a multifactorial value judgment, and a lot hangs on the witness evidence and the credibility and the pictures and the features of the building. And you just don't know how individual judges are going to react.
No. Just out of interest, what is your experience of something like asbestos being in a property? Would you feel that would, because clearly it is uninhabitable until such time as it's removed. Asbestos sort of has gone through stages in a life cycle. I mean, it's very much sort of a nemesis generally, but doesn't always seem to be when you're trying to claim some sort of relief.
Well, that's a very interesting question, because as you know, Amanda, there are various types of asbestos and various levels of danger.
Yeah.
And I represented some clients last year who had claimed uninhabitable dwellings rates, in other words, non-residential rates, on a house they had purchased that had some asbestos, I think, in the bathroom around gas boiler. Perfectly safe, inert asbestos. And just to give you an example of the dangers for clients here in getting involved with dodgy reclaims companies, they had been approached. They were from overseas, had no knowledge of the UK tax system. They'd moved here with their young infant, bought this property, and had been approached by a claims company, and were essentially told, because there was some asbestos in the bathroom, you've got an uninhabitable dwelling, even though they more or less moved straight in. And HMRC were investigating this claims company, and they put the young couple under criminal investigation for making a totally dubious claim. And I accompanied them to the interviews under caution, which is quite unusual in a way, because they brought their infant along in a pushchair because they didn't have childcare.
Right.
And so when one of them was interviewed, the other one sat outside with the lovely daughter. And I sat through the interviews with them, and it was all good at the end of the day. No further action. The criminal investigators, two ladies from Manchester, were very polite and very civilized, didn't put these people under any pressure. It was quite obvious they wanted to get to the claims company, and they wanted evidence about And in fact, there was a fraudulent signature involved. It got quite murky. But the point there, of course, is that a claims company had decided there were reasonable grounds to make an uninhabitable dwellings refund claim on the basis of totally safe, inert asbestos in the bathroom. But to answer your question, I think if you've got dangerous asbestos, is it blue asbestos that's being disturbed and there are particles floating around in the air, then from my limited knowledge, I think you've basically got to knock the building down and start again. And so in that case, that would be an extreme example. But I imagine most types of asbestos are less dangerous than that.
Yes.
And if they can be safely removed, then I think Judge Baldwin's approach in the FTT, which I fully expect to be endorsed by the Court of Appeal, will prevail, and it's still suitable for use.
Yeah.
So a lot of claims companies just think the word asbestos is a sort of get my refund free claim.
Yes. Yes.
It's not. It's not.
Yes.
Wishful thinking.
And it's quite difficult explaining to somebody or just making them realise that these various elements that are within the home, and clearly you wouldn't want your family living in those circumstances from the date of completion, but that doesn't entitle you to necessarily claim a relief. And it could be that the works can go on for several months, but ultimately, if that property is then going to be suitable as a dwelling at the end of it, then it's likely that your claim will fail.
Yes, I think the uninhabitable dwellings category is not the gift that keeps on giving that some claims companies. Of course, they were all, as you know, they were all fueled by this ridiculous process now, check later refund policy that HMRC had, which enabled, and I see this all the time, it enabled claims companies to say to prospective clients, look, we've got a track record here. We've had 20 refunds in the past month. Not playing down the fact that HMRC were likely to roll up in 8 months' time and ask for the money back with interest. Meanwhile, the poor client has lost their 25% commission.
Yes.
And left in the lurch. But I think HMRC have taken steps now. A client told me they blocked refund claims for uninhabitable dwellings since about October.
Right. Okay.
They're going to make them now. And basically, until they've reviewed the claim, and then the person refused, and then you'd have to appeal.
Yes, sure.
What they should have done in the first place.
I was going to say, but at least with that feels like more of a fair process, so that you can still make the application. It's going to be reviewed. It's going to be refused after it's been reviewed, but you then get the opportunity to appeal, and then you make your decision from there. The idea of just automatically refunding somebody was just nonsense.
Well, it was clearly a resourcing decision by some accountant in HMRC. They thought, well, we can reduce the numbers here by adopting this policy without thinking through. Just gave great succor to the dodgy claims.
Yeah, absolutely. So yes, so the bacon factory, that's that's a good one to look at.
It is. I was surprised by our defeat in that case because there had been commercial use of the ground floor, and prior to the effective date of the purchaser's transaction, the ground floor was being used by the seller's wife as a sort of recycling studio for materials for interior decorating, sort of sustainable interior decorating. So she'd get surplus decorating materials, say from hotel refits, recycle them and offer them to interior decorators and people who are doing up their own homes. Now, in the lead up to that case, HMRC had resisted and said that's not really commercial, even though business rates were being paid on the ground floor. There wasn't planning permission for residential on the ground floor. And all the evidence suggested it was commercial. And the EPC was also for business premises. There were separate EPCs between the residential part and the non-residential part. And the seller's solicitor told the buyer's solicitor, well, when we bought, we got non-residential mixed use, and I'd fully expect you to do. And in fact, the seller's solicitor produced the general commercial conditions contract. So the whole get-up was, you've got a mixed use purchase here. But two things to say about that. Just before lunch on the day of the hearing, HMRC conceded that there was genuine commercial use on the ground floor, which was, I said to Judge Voss, that's a very important concession, given that HMRC's guidance on mixed use says that where you have a property that is residential with commercial use in part of it, then you will generally have a mixed use situation. And that, coupled with HMRC's concession that it was commercial on the ground floor, I thought, well, that's pretty clear.
And the planning for non-residential use.
Yes.
Yeah.
And the other unusual point about that case was, as Judge Voss remarked, it's normally only the seller who actually can give evidence about the commercial use up to the effective date. But normally with mixed use cases, it's only the buyer giving evidence or saying what the position was. Now, in our case, the buyer, having been led to believe that this was a mixed use purchase, once HMRC inquired and challenged the mixed use classification, put pressure on the seller to assist in defeating HMRC's challenge. And they were initially reluctant to help, but then the buyer solicitor threatened to sue the seller for misleading her if they didn't help with the case. And the seller and his wife then became very cooperative and gave evidence by video during the hearing. It was an in-person hearing at Taylor House, but the seller and his wife gave evidence by video. And HMRC remarked to Judge Voss that, in effect, he should take the seller's evidence about what the seller said was undoubted commercial mixed use. He should take that with a pinch of salt, because the seller had been threatened with litigation if he didn't cooperate, which is an interesting point. You don't normally see that sort of back and forth in tax litigation. But Judge Voss remarked in his judgment that, notwithstanding that, he found the seller's evidence credible and honest and so on. So he discounted that pressure that had been put on the seller. But yes, Judge Voss, I think, was persuaded by the incredibly flowery language of the selling agent. I think it was New York based, actually, who described the ground floor as an incredible party palace.
Almost like a party basement.
Yeah. Now, we explained that. It didn't go down particularly well with Judge Voss, or didn't convince him. We said that there was going to be a gin distillery down there. That was the seller's original conception when he bought the property, was to create a gin distillery as a branch of something I think called Wolf Distillery from Australia. I think he had an Australian background. And those negotiations never actually were finalized. But in the meantime, there was a still in there. And he created what you could say was a party space, but he explained it was actually an entertaining space associated with the distillery. So you could invite clients along to taste and sample in a very relaxed, comfortable atmosphere, not your traditional distillery in a warehouse somewhere. And that's why it was kitted out with lounge furniture and carpet and so on and so forth. But that, coupled with the selling agent's language, I think persuaded that got HMRC over the line about suitability for use. You could wander down and just enjoy it as a sitting room.
Yeah, because one thing that I noted was how they made reference to the connecting staircase and the fact that there was no clear delineation between.
Yeah.
Do you think that would have made, given what you've said and the way that they really looked at it anyway, do you think that would have made any material difference to have had almost, closing doors or something quite a more clear delineation between the basement and its use and the remainder of the house? Do you think that would have made any difference?
I think because there weren't independent occupiers for the ground floor, even if you'd had lockable internal doors, the owners could have just wandered down or left them open and used it. Another factor was the car lifts. So in the basement, there was storage for cars, and you drove in at one end of the building onto a platform, and your car was lowered and neatly stored away out of sight. And that was on the ground floor, the car lift. So, there are a number of aspects that suggested the ground floor could easily be put to residential use.
Right.
So I think that at the end of the day, I think that was the reason for the suitability.
Yeah. Because, and I think again, it just shows that in sort of irrespective of the planning permission, the previous use, it's evidence from the sellers, it still didn't qualify. So it's a high bar.
Yes, I was surprised at the decision, particularly. I think I've got the reference here. SDLT M00390 says that if you've got commercial use of part of a residential property, then that part will normally be regarded as commercial. So as I mentioned before, because we had HMRC's concession halfway through the hearing that it was commercial use, coupled with that guidance, I thought, well, that's probably going to get us over the line. But clearly I was wrong on that, and Judge Voss took a line against us on suitability for use. So.
Yeah. Another great example as well is where HMRC's guidance is purely that, and they don't necessarily follow it. so it sort of makes it tricky for everybody else reading their guidance that might want to interpret it as the way that they'll operate. But I think the mixed use point is something that is really important and an interest. So Sutawalla, last year with the grazing rights and when a ground's ancillary to the property, there doesn't seem to be again any really clear sort of focus about when you can suggest that maybe somebody buying with 7 acres, because 7 acres is clearly in excess of garden, and yet there have been obvious examples where that's not been able to claim mixed use.
Yes, I think the FTT in Sutawalla, Judge Rankin, made his own evaluation on the facts. And then in the upper tribunal, the judges took if I may say so, an extremely correct approach to how you handle appeals from the FTT, i.e. was there either a legal error or was the judge's evaluation of the facts so unreasonable or irrational, to use the term, that no reasonable FTT could have arrived at that evaluation of facts. And they said on both points, no, there hasn't been an irrational approach by Judge Rankin, and he didn't actually make any legal errors.
Yeah.
So we refuse HMRC's appeal. I thought it was a very correct approach to the position. I must say, HMRC all along regarded Sutawalla as an aberration, that the FTT going off on one, and that they were sure to be able to set it right in the upper tribunal. And at the end of the hearing, they were cock-a-hoop. I'm sure that they thought they'd won, but obviously they didn't. So that was Sutawalla was a very satisfying victory for the taxpayer and for me as counsel, and it was part of a very unusual situation, not only for me but generally for taxpayers in the tax tribunal, I won 3 cases on the hop. It was a hat trick. We had Ghislaine Desai on mixed use, Sutawalla, and Davis and Gilbert, of course. So it was a very happy summer as far as I was.
Good run.
And the Ghislaine Desai decision was again a mixed use decision, 12 acres of woodland that was held not to form part of the grounds of the magnificent dwelling. And I think the judge in that case was a little bit irritated by HMRC's approach because Mrs. Ghislaine Desai had given her evidence and explained to the tribunal that these 12 acres of woodland just did not, you couldn't see them from the dwelling or the garden. They were used by the public, and really she'd never regarded them as, she had to acquire them as part of the purchase, but they just weren't, in practical terms, part of the grounds. And then HMRC's argument was to contradict her evidence and say, well, you could see the wood from her dwelling and garden. And that was based on a photo in the estate agent's brochure that was a misdescription. It was a photo of the wood, but it described, for some reason, it described it, suggesting that you could see it from the garden. And the witness had carefully explained that that was an error. You couldn't. And then her predecessor had got fed up with members of the public in the woodland looking into her garden and had planted a tree screen to prevent that. But HMRC directly contradicted her and said, no, you can see the woodland from the dwelling. And at that point, the judge quite correctly intervened and said, well, has anyone from HMRC visited the property? And of course, the answer was, well, no, almost an indignant, we never do that. Of course they don't. And he said, well, how can you contradict the person who lives there? And so he very politely put them in their place and said, I'm going to take their arguments on that with a pinch of salt.
Yeah.
But that's a good example when you can, the mixed use cases seem to fall into 2 parts. One is where you've got commercial use, such as the Trechikov case. And the other is where you're simply arguing that the extent of the land is not part of the grounds, which is more, Ghislaine Desai and Sutawalla.
Yeah.
So yes, the mixed use cases are difficult to predict, and you get asked about purchases of farmhouses that are no longer used as a farm but with 100 acres, and you have to start asking yourself all sorts of questions about, do the 100 acres provide a treasured view, or safety and privacy and security? Is there a grazing agreement?
Yeah.
So on and so forth. And then, can we produce a grazing agreement? Or can we enter into a grazing agreement when we buy? Will that be sufficient? So all sorts of issues come up.
I think the treasured view point is, really subjective and quite a tricky, tenuous one to claim. But I think that if you're buying, a grade 1, grade 2 listed beautiful property set in its grounds, then I think again it's tricky to claim anything other than those grounds are enhanced by and part of the property that you're buying, rather than excessive and therefore potentially for mixed use, as you say, unless you can produce an agreement to the contrary, really, with the local farmer.
Exactly, and you'll often be done for by the description in the estate agent's brochure.
Yeah.
Somebody ought to take estate agents aside and have a seminar on how not to write descriptions.
Well, it was when I was at probably doing A-level law, I suppose, maybe law school, it was always termed to be, estate agent's puff, or, whereas that puff now seems to be quite heavily relied on in some of these cases. It seems to have more weight attached to it than probably anybody's really ever applied any weight to an estate agent's particulars. You just need to have a look at a few of them, and their descriptions of things are are way off when you actually go and visit properties often. So it's interesting the weight that's being added in these cases.
Well, it is very difficult when the judge looks at the estate agent brochure describing the treasured views and the privacy and security and the wonderful land surrounding their home as part of its grounds.
Yeah.
To say to the judge, look, actually, they're not part of the grounds. If you're told to argue that, you will, but you're going uphill.
Well, was there anything else you would like to update us on?
Well, I think just in the last few minutes, just say a couple of general points about Spotlight 63.
Yes.
So I think we are getting inquiries about this very sad situation and what can be done about it. This is a sort of putting land into a sort of hybrid entity, to claiming SDLT relief, and there are said to be capital gains tax advantages and inheritance tax advantages. So typically putting land into an LLP. And the two main points, I mean, I've not looked into these in detail, partly because no one's actually paid me to do it. I've been approached a number of times and had general discussions, but never got round to being instructed on the matter to provide an opinion. But the immediate takeaways for me are that the scheme, I think there's a lot of detailed criticism of the scheme out there on the internet by people who probably know better than I do. But my immediate takeaways are to ask, is there mortgage fraud here? Because the terms of the mortgage will normally require you to at least notify the lender and get consent if you're doing any of these sort of dealings in the land.
Certainly when Simon and I were approached, probably, well, Spotlight 63 must be 18 months now, mustn't it, since that was released. But when we when we were approached, 4 years ago, often clients would come and talk to us about incorporating their property portfolios. And the sticking point for us always was, well, you're going to have to refinance the portfolio. And I think that the reason that the promoters were getting away with not notifying lenders was because they weren't actually using firms of solicitors to transfer the title, and they were creating this very artificial structure that meant that the client was holding the property on trust in a very, convoluted way, that whether or not they'd signed the documentation or whether they hadn't signed the documentation as to whether it would actually be operative or not. But fundamentally, it did breach the mortgage conditions, because the mortgage conditions clearly state that if there's any change, whether beneficial or legal, within the title for the beneficial or legal title, then consent was required. And I think that probably over the last 5 or 6 years, lenders' terms have been adjusted as well to reinforce those points. But if you weren't using a solicitor to transfer the title, file an SDLT1 and look at the charge on the register, then they were sort of seeking to circumvent that. We contacted the Chartered Institute of Taxation regarding the point of, acting for somebody, and really remaining on the preferential rate was mortgage fraud. Because if the beneficial title is now that of the companies, and they're the person that's entitled to the capital and the income that's derived from that, then it was a big problem. And I think even now, we had a conversation with somebody last week, and they were saying, well, we're going to stagger in the properties as they come in. We're going to incorporate, or we've been told we can incorporate the property portfolio in a staggered manner, so we can wait for the fixed rates to expire. Well, what kind of commercial agreement would you be entering into where you had one party that's agreeing with another party? Oh, yes, you can just bring in those properties whenever you like in order to continue to benefit from fixed rate periods. It's just not going to happen. So
I wouldn't want to let a criminal lawyer or white collar fraud lawyer look at that.
yeah,
Fear of all sorts of charges they would come up with.
Yeah.
So it's
yes. I mean, the hybrid structures where, they fell down on a number of elements, whether it was the claim that BPR was available and inheritance tax, significantly reduced. There'd be no SDLT payable. But I think the mortgage fraud is a point that's quite commonly overlooked and doesn't have a great deal of weight necessarily attached to it. But as a solicitor that specialised in property for years and years and years, it's such an eye-catching point.
well, exactly. I mean, it goes all the way back to, there's a case called Mortgage Express.
Yes.
On mortgage fraud, which a good friend of mine did. A good friend of mine at the bar did the case, and any misleading of the lender is basically forbidden.
Yes.
Particularly for financial gain. The other thing I wanted to say before we close about that spotlight and those schemes is rectification as a solution. Because there's a declaration of trust involved, the remedy of rectifying, if the innocent client didn't really know what they were getting involved in, may be worth exploring. There's been a couple of recent helpful cases where judges have allowed rectification, even though there were tax implications involved.
Okay. And
the innocent clients I've spoken to were clearly misled. It's all above their head. And I just, it would be interesting to put them before a High Court judge.
Yeah.
To say, look, we had no idea what was going on here. We thought we did, but clearly we've been tricked. And we'd like you please to roll the whole thing back to step to the starting point. So we can avoid HMRC's attacks by saying, well, these things have never happened.
Yeah. Yeah, no, I think that's also a good point. We did have a look at this last year in terms of mistake and looking to see whether or not you could rectify the situation. I think at the time that we were asking the questions, there was the opinion was that it was less than 50% chance of success. But I think that there's going to need to be something just to push it forward, because HMRC are not in any hurry to answer questions particularly or resolve. There's no pressure on them, and yet lives of clients are literally on hold. They can't get lending, they can't unravel, they can't move forward, they don't know what their tax liabilities are, and that does need proper attention.
Well, particularly clients who say, I was speaking to somebody the other day with 40 or more properties that have been put into, it's the family's income, the buy-to-let empire.
Yeah.
And they were persuaded to do this and bitterly regretting it now. And they don't see what they can do, particularly given HMRC are in no position to deal with this quickly. But it just struck me rectification might be worth exploring.
Yeah. That's a good point.
Yeah.
Well, that's fantastic. Well, thank you very much for your time and your expertise as always. It's really good to talk to you, and I just think with all of the SDLT cases, it's the case as ever it was, but even more so, I think that everything does seem to turn on its own facts, and they don't fit into these nice little tick boxes that people would otherwise lead you to believe. So it's always really important to get specialist advice.
Yes, I can only endorse that, Amanda. Thank you.
Yeah, so thank you for your time, Patrick. It's been a pleasure as always to see you. So and hopefully I shall see you soon.
All right. Likewise.
All right. Okay.
Great talk.
Thanks very much indeed. Thank you. Bye.
Thanks for listening, and tune in next time when we discuss more of the tax and legal issues surrounding your business and property needs.